Lukey.
Okay.
Good afternoon, and do you want to state something for the record, Ms.? Welcome, Ms. Lukey, and the members of the Commission of Judicial Conduct. I can see you sitting at the back. We very much enjoy being in this new courtroom, but one of the problems is that the sound system is so good that everybody sits at the back of the courtroom, and so it looks as if I'm speaking to an empty courtroom here. Ms. Lukey, would you like to make a few opening remarks?
Thank you, Your Honor. I would. Good afternoon. As you know, my name is Joan Lukey. I've been asked by the Commission on Judicial Conduct to act as counsel to them in connection with certain inquiries from this court. You may be asking yourself, why would they wish to have counsel? And the answer is that the inquiries you have made raise very complex and interesting issues of constitutional law and of statutory interpretation, and hence they sought to have some outside assistance with this effort. I have been asked to convey to you from the very beginning that the Supreme Judicial Court that the Commission on Judicial Conduct, which I will call just the Commission, fully recognizes and acknowledges that the Supreme Judicial Court has the inherent authority to supervise and discipline judges. The Commission does not now, nor has it ever, sought to derogate that authority, nor could it lawfully do so under its enabling statute. And by law, although the Commission has 3 appointing authorities, it is to this court and this court alone that the Commission reports. That having been said, it's clear from the questions that have been received from the court in recent weeks that there is an area of concern that has arisen, and specifically, that relates to an amendment to the enabling statute of the Commission, which was passed in 1987 and became effective in 1988. As you, of course, know, the Commission is a creation of the legislature via Chapter 211C, and its authority to act is derived exclusively from that act, Chapter 211C. What happened in 1987 is that a provision was added for the first time which allowed for an informal resolution or agreed disposition between the Commission and a judge against whom a complaint had been filed without any report to this court. That was a change from the structure that had been in place since the enabling statute was first created in 1978. The amendment came about as a result of a request of the Massachusetts Judges Conference, reportedly because that conference sought a mechanism which would include permanent confidentiality, not simply from the public, as to which a mechanism already existed, but with regard to this court, which is, after all, the overall supervisory court above all other judges of the Commonwealth.
So let us propose the following. Let's assume that the Commission, through an agreed-upon resolution, or through the agreed-upon resolution, a judge is suspended for a period of years. That comes to the attention of this court, to the public, presumably in the form of a press release. If we were concerned about the underlying facts in the case, could we ask you for that information, or would we have to start our own proceeding?
Your Honor, you would have to start your own proceeding. As we have attempted to explain in the written response to the inquiries, Section 6 of Chapter 211C, which is the confidentiality section, precludes the Commission from sharing the information that has been gathered in the course of its investigation unless the matter has proceeded to public hearing, that is, going forward under Section 8.4 rather than under Section 8.1, the agreed disposition or informal resolution section. That means that you cannot come to the Commission, even as the supervisory court, and require the Commission to reveal information to you
Ms. Lukey, let me just interrupt you if I can for 1 second. I think that, at least from my point of view, and I suspect from the Justice's point of view, that what is at issue primarily this afternoon is a question of statutory interpretation. In other words, I think that the Justices appreciate your recognition at the outset that there's a general superintendent's power here. I don't think that's what's in dispute. It is a question of statutory interpretation, and while it is helpful to know what the practice of the Commission has been, I think that most of the questions will be directed towards the issue of statutory interpretation. Let me begin, if I can, by asking you this question. When we try to do statutory interpretation, we try to look at the words of the statute. In Section 8, which is reflected in Rule 7 of the Commission, there are several terms that are used. And it seems to me that one of the central issues here is the difference between the term conduct, which is used in connection with the informal adjustment process, and then sanctions that are contained within Section A3 4. As I read the Commission's submission, the Commission did not place any limitation on any agreement that it entered into with the judge, because it would only be with the judge's agreement, as to what the nature of the conduct could be. Am I correct in
Well, you are
understanding?
correct, but it is not the Commission that didn't place any restrictions. It is the legislature that did not place any restrictions.
I'd like to address that if I could, Ms. Lukey. As I read your material, imposing conditions would include the imposing of a fine or a suspension. Am I right?
It could include those conditions if the judge agreed to them, Your Honor.
Okay. Well, where else in the general laws does the word conditions include the imposing of a fine or a suspension? For example, in the executive branch personnel laws, which might have something akin to this, if the appointing authority has the authority to suspend, isn't it always expressly in there? It's not referred to as a condition that he or she may impose. Or when a court is given the authority to impose a fine, that authority is specifically referred to as the court may impose a fine. The statute never says merely that the court may impose conditions. So my question to you in short is, where else in the general laws is the word conditions used as you argue it's used here to include the imposition of a fine or a suspension?
Respectfully, Your Honor, I don't believe there's anywhere else in the general laws that deals with the situation not of an imposition but of an agreement or consensus being reached.
Yes, but the words that the legislature has chosen, and those are the words that we have to construe, say that the informal adjustment can include the imposing of conditions. And I would suggest that because the legislature has never used imposing conditions to include a fine or a suspension, that they did not intend to include that here by using the word conditions.
Well, respectfully, Your Honor, I am going to have to disagree with you on that. Had the legislature chose to limit the respects in which a judge could reach agreement with the Commission, it could certainly have so indicated. Instead, it has chosen to include a phrase that might well be considered a catch-all phrase.
But didn't it do that? Didn't it so indicate it by including in Section 4 that the Commission may recommend to the Supreme Judicial Court imposition of limitations or conditions on the performance of judicial duties? And that would indicate that they were not including those in the wording of conditions on the prior page.
To the contrary, Your Honor, I think the specificity of Section 4 belies the notion that Section 3 was meant to be so limited. The legislature, I believe, intentionally
I hate to interrupt you, but where 4D, imposition of limitations or conditions on the performance of judicial duties, as we can do, but then it goes out and sets out separately, imposition of a fine. If imposition of a fine was within the imposition of conditions, why would it be repeated?
Well, Your Honor, if you look at the language here, there are actually 2 or 3 instances in which they repeat the same form of sanction.
No, of course. There are some that overlap. In other words, it seems to me that you have 2 things. One is, what can you do with the consent of a judge?
I believe, Your Honor, that you can...
No, wait.
I'm sorry.
And that wasn't the question. What can you do with the consent of a judge? You can do certain kinds of things with the consent of a judge, correct? Then it may be that the judge won't consent to any of those, and then the commission can recommend those same things because the commission may have determined that the most appropriate thing, for example, is retirement, which is one of the retirement is one of the ones that is overlapped. So in other words, the commission reaches an agreement with the judge retires voluntarily, that's the end of it. Clearly the statute provides for that. The commission decides that a judge should retire, judge does not agree, makes a recommendation to the court can then consider, for example, retirement or removal.
Actually,
Correct?
Your Honor, that's one of the things that indicates the problem with the drafting of the statute.
Well, that may be,
The fact
there
that it
may
still
be, there
includes
may be a
removal.
constitutional problem to
Yes.
that, but that's not a question of delegation of duties, okay? I mean, in other words, I think we have to look at what the legislature said, and that's why I pointed to removal. It may be that somebody that if, for example, the commission recommended removal, I can fully understand that a judge might say, the Supreme Judicial Court doesn't have the power of removal. That's different. I mean, the legislature from time to time will draft a statute that doesn't pass constitutional muster. That is different than saying, what has the legislature said the commission may do?
Yeah. Let me sort of intervene for a minute. First of all, I don't see any constitutional problem here at all. I mean, you conceded at the outset that this Court has the last word on any of these things, and if, frankly, we wanted to object to something you people had done, even the Commission had done, even if the judge agreed to it, we could just simply send down an order under 211.3 saying we wanted to look at it, and so on. Second, I think I'm the only one up here that actually was party to the negotiations that led to this revised statute. At the time, the Judges' Conference had gone to war, so to speak, with the Conduct Commission, and Chief Justice Hennessy asked me to mediate the violent disagreement between them and the League of Women Voters, Florence Rubin and others who were involved in the thing. And we came, and eventually after a year and a half of negotiations, we came up with this revised statute. And I question whether in Section 8, 1 sub C, when you're talking about conditions on the judge's conduct, it was ever intended at that time when we negotiated this to an agreement and the legislature agreed to enact it, that it would lead to agreements with judges to, for example, not sit for a year, resign as presiding judge. I think it was intended to cover things such as, look, you know, people are talking about you, the judge, because you're going down to Mohegan Sun constantly and gambling. So that's your conduct, stay out of Mohegan Sun. Or you're going to a bar and you're getting a reputation for going to the bar, stay out of the bar. And I think, and it's been alluded to by my colleagues already, that 4 sub D, imposition of limitations or conditions, pick up the kinds of things that where we're having our disagreement with that the Commission has been doing, where people agree not to sit for a certain period of time or resign as presiding judge. And that's perhaps what we've got to straighten out here. I don't know how we do it exactly.
I understand what you're saying, Your Honor. I would point out, you already know this, for 18 years the Commission has been interpreting the statute to give it a broad
Ms.
swath.
Lukey, that may be correct, but as I at least looked at the submissions, with respect to the ones that I would clearly classify as conduct, and I turn to the Commission's own informal description of what conduct means, which is contained, I think the annual report is the last report of the Commission, the last published report, and in its prefatory statement, trying in lay terms, as I understood it, to describe conduct, it says the terms may include counseling, education, assignment of a mentor judge, monitoring by the Commission for a specified period of time, voluntary retirement, or other appropriate conditions. It then goes on to say that there is something more severe than conditions, which is a private reprimand. I think the question is not so much what has the practice been, but the troublesome part, as I see, among others, is the following. If the judge engages in conduct, which is really serious conduct, and if the judge can reach an agreement with the Commission for the imposition of a sentence, of a discipline, not linked specifically to what I would phrase conduct such as counseling, or in the words of the Commission itself, to prevent a repetition of the misconduct. In other words, it is not just to prevent it, there is a discipline here. Because, as you know, part of what the statute provides is that you are to make recommendations regarding discipline. That's in the statute, Section 2. If, for example, the Commission imposes a discipline on a particular conduct, which, for whatever reason, because the Commission chooses not to go to a formal charge but decides it's a kind of plea bargain, but it is a discipline that this Court does not consider severe enough. The Commission's answer is, well, the Supreme Judicial Court can start its own investigation and impose a more severe problem, a more severe discipline. It struck me that that was a quite extraordinary reading of this statute. A quite extraordinary reading, because what the statute was designed to do was to provide the Commission with certain powers where it had to deal with the conduct of a judge, but to make recommendations regarding discipline. And it is hard for me to see that what the legislature intended to do was to have one proceeding for one particular act. Let's assume there's only one act. So this is not an ongoing, problem with substance abuse or problem with intemperate behavior. There's one very serious act. And first you enter into an agreement with the Commission, and then this Court starts all over again?
Well, Your Honor, the legislature did not limit the categories of conduct or of sanctions that could be dealt with on informal resolution. Respectfully, I'm hearing questions, and as is often the case with this Court, haven't had too much opportunity to actually respond.
Well, at the moment, we're just the justices. We're not even a court at the moment.
All right. In responding, I would say this. Had the legislature wished to add this provision, which does not include a report to this Court, to be limited to certain categories of conduct or certain categories of sanctions, it would have said so. Much of the complaint that I am hearing coming through in these questions is complaints with the drafting of the legislation. And
no,
Justice
it's a question
Rainey,
of statutory interpretation.
Yeah.
It's trying to understand what the difference is between imposing conditions on the judge's conduct, and as contained in under Section 8(1)(c), and the list of recommendations to the Supreme Judicial Court for removal, retirement, imposition of discipline as an attorney, imposition of limitations or conditions on the performance of judicial duties. In other words, D is one of those, and you're simply saying that D subsumes all of them.
Your Honor, what I am saying to you is that the legislature intentionally created a provision which was unrestricted in the nature of remedies or sanctions to which a judge could agree. Because it was by agreement, it is broader than what the Commission may recommend to this Court, and respectfully, it is broader than what this Court may constitutionally do.
I don't think so. I don't think there's any legislative history there to support that. And the negotiations, I think, were such that that was not the actual intent, and that somehow we've got to tweak these two provisions to get them more in sync.
Could I ask you, for example, as I read your sort of historical examples of certain dispositions that have been agreed to, Section 8.3 suggests the Commission may issue a private reprimand with the consent of the judge.
Which probably should have been labeled as E under 8.1. There's no reason why it's any different from the others.
But there it is. But as I read it, in the past, under the rubric of imposing conditions on the judge's conduct, some of the agreed informal adjustments have included public reprimands. Is that correct?
By agreement, that's correct, Your Honor.
So if this concept of imposing conditions on the judge's conduct includes a public reprimand, under your interpretation or the Commission's interpretation, why would it have even been necessary to include 8.3?
I don't think 8.3 even belongs there, Your Honor, but
it's there. And when we're interpreting it, we have to give meaning to the cohesive whole of the list. And I think that's one of the problems we're all having in reading as broadly as you do. Imposing conditions on the judge's conduct, in your view, means anything, as long as he agrees to it.
That's correct, Your Honor. Basically, the view is any condition which the judge finds acceptable is a permissible portion of an agreed disposition.
Well, how, for example, a fine a condition on the judge's conduct?
That's my point.
It's got to be on his conduct.
Conduct.
How is a public reprimand a condition on his conduct?
Well, if I may, Your Honor,
strange.
a fine does involve conduct because the judge is obviously taking some action in order for the fine to be paid.
But so, Ms. Lukey, is retirement.
Which is separately dealt with.
Yes. In other words, what you are saying is conduct is everything, and what that seems to me is a very simple statute that says, with the agreement of the judge, the Commission can impose anything, and if the judge doesn't agree, the Commission can make a recommendation to the Supreme Judicial Court.
That will be different and possibly lesser than what was proposed as the agreed disposition.
Or more.
Or more.
Or more.
But it's limited. Section 4
I understand
is limited.
that, and it seemed to me, and I had some difficulty with it, which is, in essence, it may well be that that is what the Commission has been doing. First of all, I don't think that that's determinative of a statutory interpretation, but I think that faced with the language, and particularly in light of the Commission's own description of what it thinks conduct means, several times when you said, well, it shouldn't be there or it should be in a different place, isn't very helpful to me, I must say, because obviously there are cases where what the Commission, and there may be ones that were never made public, although I would doubt it, because if a judge agrees not to sit for 6 months, I can't imagine that being not known to the justices of the Supreme Judicial Court. A judge being reassigned, I can't imagine that not being known. But let's assume, for example, a judge agrees not to sit in a particular on a particular set of cases. Where's the authority of the Commission and the judge to agree that the judge won't hear certain kinds of cases, for example?
Well, we say that the authority is under Section 8.1c because that would be a condition on the judge's conduct.
But again, I go back to how can conditions be read that broadly? What in there gives you the view that conditions is that broad?
The fact that it isn't limited in any fashion, Your Honor, whereas the enumerated provisions of Section 4, which is the part that is not by agreement with the judge, is in fact limited.
Could you view?
But
could you view that
4H is certainly a catch-all. Imposition of any other sanction, which is reasonable and lawful.
Which includes anything. So 4 includes everything, the specifics from A through G, plus the general of anything else in H. But could you not view Section 8.1 as being, as the legislature intending to include private forms of discipline within 8.1 and public forms within 8.4. And I say that for the following reason. If the agreement is that the judge shows up and works from 9 to 4, the public won't know about that because the judge is supposed to do that anyway. Or if the agreement is that the judge will not yell at court officers, the public won't know about that because that's normal behavior. Or even if that the agreement were that the judge not sit on criminal cases, theoretically that's something the public would know about. But if the commission suspends a judge for 1 year and puts out a press release about that, or even if it doesn't, that's a public disposition. The judge isn't seen on the bench for 1 year. And that's the type of sanction that's included in 4. 4 of those public, any things that would be known to the public, removal, retirement, discipline, limitations on the performance of judicial duties. And those are the things that the legislature intended to include in 8.4, whereas 8.1 is the private kind, such as an admonition, professional counseling, conditions that he go to do this, do that he's supposed to do just to perform his work, or retiring voluntarily. Those aren't in the nature of public sanctions.
Respectfully, Your Honor, I'm not sure where you're reading the word private into the legislature's list there.
I'm just saying it could be one way of viewing it.
Well, admonishments can be public as well as private, Your Honor. A retirement early is public. It is not private.
But nobody would know why it's being done. Judges retire early all the time.
Well, since the Court has been very focused on the specific language of the statute, I would ask you to be focused on the fact that you are now writing in a limitation that the legislature did not put there.
Ms. Lukey, could I just ask you this? Could you explain to me what the difference is between Section 8.1c, imposing condition on the judge's conduct, and 4d, imposition of limitations or conditions, in particular, on the performance of judicial duties?
Well, we suggest...
What is the difference between conduct...
Well, the first is broader than the second. The second is a subset of the first. The imposition of limitations or conditions on the performance of judicial duties is a subset of the broader category of imposition of conditions on the judge's conduct. The judge's conduct on which conditions may be imposed by agreement may relate to his conduct outside of the courtroom, as the example was given earlier, his conduct with regard to going to a bar with too much frequency. That is not the performance of his judicial duties. It is certainly a condition which may be imposed. So the Section 4 conditions, which are not by agreement, are more narrowly circumscribed, although the Court has suggested that any other sanction which is reasonable and lawful could be viewed as a catch-all. I actually believe that the issue of lawfulness and reasonableness may be more limiting than this Court realizes. The Commission believes that if the judge is in agreement with certain conditions being imposed, those conditions are acceptable under this statute, even if this Court could not force them on the judge.
No, I understand that. Voluntary retirement is not removal. I understand that. But one can do anything voluntarily that, that one or other branch of government may not.
It seems, I think, where the disconnect is occurring here.
Well, it's not a disconnect. It's really a question. I would agree. There are 3 possible ways to look at this. The one is that judicial conduct and the performance of judicial duties are 2 different things. A different way to look at them, I understand you, but I'm just saying, a different way to look at them is to say they are identical. And a third way to say them is one is larger than the other, and it is the Commission's position that the universe is included under conduct and the performance of judicial duties is a subset. I understand that.
That's correct.
Could you explain to me in what circumstances, given that judges are not permitted to practice law, 4C was designed to address the imposition of discipline as an attorney?
Well, as we indicated in the written materials, the Commission does not believe that it has authority to impose conditions that relate to the practice, to a judge acting as an attorney.
But what the Commission is telling me is it can do anything
I can answer
voluntarily.
that for you. If a judge, I think that was intended, if a judge if the recommendation of the commission is that a judge resign and he says, I won't do it, and since he can only be removed constitutionally, as I understand it, by bill of address or impeachment,
Correct.
one way that this court, and I think there's actually cases on it, has done it before, is to enjoin him from sitting or take some other form of action that might involve his status as an attorney, maybe a recommendation of the BBO or something like that. And since you have to be, as I understand it, a lawyer to be a judge, that would, in effect, perhaps remove him from the bench, maybe. But it's there. And you were going to say something about it, because what does it mean?
Did I understand you correctly to say if the judge, you can only do things with the only thing that you can do, all of the things that fall under conduct, you're saying you can do as long as the judge agrees, correct?
Well, except that the exception was carved out in the written submission based upon the 18-year practice of the commission, that it does not, by agreement, impose conditions that relate to the individual practicing as an attorney. There is a different body charged by law with that responsibility. It
But
can make
if the judge, there is a different body of law that says a judge can no longer sit as a judge. If a judge can do it voluntarily, you're saying that the judge can't agree to do that voluntarily?
a judge can agree to do whatever he wishes to do voluntarily, Your Honor. That's the nature of agreement.
Right.
However, the written submission indicates that when it comes to some form
No,
of
I read-
sanction that relates to practicing as an attorney, that is sent to the court as a recommendation.
Surely
and this
that
is a matter
has to do with practicing as a judge as well. In other words, there's a different, there's a separate body of law. There is a Chief Justice for Administration and Management. There are Chief Justices of trial courts that assign judges.
Yes.
That is what they are charged by law with doing.
Right.
They tell them which courts to sit in, they tell them which cases to handle, they tell them which time standards to manage by. And as I understood your position with respect to discipline, you can't say to a judge, you can retire, you can practice as a lawyer because you have a JD degree and you're qualified, you're a member of the bar, but you can't handle driving under cases because what you've been convicted of is driving unders, but you can do landlord-tenant. As I understand...
As an attorney?
Yes.
We do not, the commission does not do that, Your Honor.
No, I understand. And your reason for not doing that, you say, is because there's a whole other set of requirements that says, you know, how you can and cannot practice law. Am I
And
correct?
there's a board of bar overseers as well, Your Honor.
Yes.
And the commission attempts not
That
to
is-
intrude upon the
Right. There's a
prerogative of that
statute
board.
that tells the courts how judges are assigned, to what courts they are assigned. In fact, the governor appoints them to particular courts. There are arrangements within the courts as to where some, but the commission is saying, but we can reach an agreement with the judge that you won't sit in certain cases, that you won't sit in certain areas, that you will agree not to hear certain things, notwithstanding this other statutory, in fact, it's statutory body of law. And I'm trying to understand why the Commission takes a different point of view when it's the Board of Bar Overseers as opposed to 211.3 with the Chief Justice for Administration
It does not. In the same section of the written response in which we told the court that we do not, that the commission does not take action with regard to conduct as an attorney, the commission also informed this court that it does consult with the Chief Justice of the particular
Does it
department.
consult with the Chief Justice, informing the Chief Justice the reasons why?
It cannot tell the Chief Justice anything that is covered by confidentiality unless there is a waiver from the judge who is affected.
Is it possible for the Commission to reach an agreement? Let us assume that the justices have a different statutory interpretation than the one that the Commission has. Would it be possible for the Commission to reach an agreement with the judge that, for example, touches on what I would say the performance of judicial duties, such as that the judge will not sit for a year, or the judge will not sit in this part of the Commonwealth, or the judge will not sit on particular kinds of cases.
Well, that's what we're here for. That's
Wait a
what you've
minute.
been doing.
Yeah, no.
No, Your Honor, it is
wait
not
a
what
minute, let me
Commission has
finish.
been
To
doing.
reach an agreement with the judge,
Agreement.
subject to make that recommendation, the Commission and the judge agree that they would make the recommendation to the Supreme Judicial Court. The judge in that case, presumably, would be able to waive his or her confidentiality solely with respect to informing the Supreme Judicial Court. In other words,
Yes, that can occur.
that could occur.
And
In
it
other
does
words-
occur in the cases that Justice Graney indicated he thought that the Commission was already engaging in the conduct of, for example, saying that a judge would not sit for a year without consulting the relevant department chief.
You would have to.
The answer is that part of, without reference to any specific case,
No,
because
of course not.
it
There-
can't be
there
a
is no
reference to a
case, yeah.
specific case. What happens is, as part of the agreed disposition, the judge releases the commission to go to the department head to gain the approval of that aspect of the agreed disposition. It is not, the commission is not, this isn't a bunch of cowboys who are out there
Mr.
making
Lukey,
decisions.
Nobody is suggesting that. Nobody is suggesting there's a particular case. The issue that we are trying to explore is where concerns have arisen and going to look at the statute, where's the difference of statutory interpretation? There's no suggestion that anybody has been acting deliberately in violation of a statute. There's no suggestion that the Commission has been doing anything other than proceeding in the utmost good faith to reach an agreement. What I'm trying to explore with you today is, assuming that there might be differences of interpretation, what the ramifications of those are. One of the ramifications, which the Commission very thoughtfully drew to our attention, was, in light of the confidentiality provisions, is it possible to have some place between imposition by agreement and recommendation to the Supreme Judicial Court without going through formal charges? It seems to me that the Commission appropriately has developed a procedure where it involves a discipline, you would say it's not a discipline, which touches on the performance of judicial duties, that the Commission has recognized that it cannot reach agreement with the judge without going to either the Chief Justice for Administration and Management or that judge's Chief Justice, the Chief Justice for whatever court, to whichever court the judge is appointed. What I'm saying to you is it seems to me that if there's a determination that with respect to certain kinds of sanctions, and I'm not asking you to agree with me on the statutory interpretation, but if this Court were to conclude that where it touches on the performance of judicial duties, the statute requires a recommendation to the Supreme Judicial Court, that could be done by agreement with the judge in confidence, making a recommendation to the court. Correct?
Well, there are two parts to that. The beginning part of your question suggested that there was a requirement of some form with regard to taking certain sanctions to this court.
I said I was not asking you to agree with me with respect to that.
That we do not agree with.
No, I understand that. But I'm saying if the court were to interpret the statute that way, in other words, the Commission has not given its view of the statute, its good faith interpretation of the statute. The Commission has not thought it necessary to come to the Supreme Judicial Court when it was reaching agreement on a judge with respect to conditions on the performance of judicial duties, correct?
In fact, the Commission has believed that it was inappropriate to do so.
Fine. The Commission has, however, recognized that where it is reaching an agreement with a judge which touches on conditions on the performance of judicial duties, it must necessarily go to the Chief Justice for the Trial Court Department or the Chief Justice or the Chief Justice for Administration and Management, correct?
Correct.
And it has not been able to enter into an agreement with the judge with respect to an appropriate disposition without that, and the judge, recognizing that, has said, I will waive my confidentiality and permit you to go and inform my Chief Justice or the Chief Justice for Administration and Management, correct?
Inform them of the proposed sanction. It generally or does not necessarily involve informing that chief of the allegations or
but it
anything
could.
else.
The judge could say, the Chief Justice of Administration and Management say, I can't agree to this because I don't know what else is there. And you go back and
then it's up to the judge
you
whether
can do
he or
it.
she wishes to release further information.
Correct. So that same mechanism would be available if this court were to conclude that with respect to certain disciplines, it was necessary to make a recommendation to the Supreme Judicial Court, correct?
Well, the mechanism of doing something by agreement is always available, Your Honor.
Correct.
However, respectfully, the Commission believes that would be inconsistent with the reason that the amendment was passed, which changed only one thing, and that one thing was whether agreed dispositions had to be reported to this court for approval, which they did have to be immediately before
I understand.
the
It is
amendment.
also possible to read the statute, and I would at least like to suggest that the Commission consider this, that one way to draft a statute is to say the Commission can do anything, the Commission can recommend any discipline, as long as it's it can impose any discipline, as long as it's by agreement. And if you can't reach agreement, it can recommend to the Supreme Judicial Court, and there's only one tiny little piece that the Commission can do without agreement, which is spelled out in the statute. That's not what the statute says.
I hope that I'm following what you said correctly, Your Honor, but I was a little hung up on the beginning phrase. The Commission does not consider, when it's acting under 8.1, that it is imposing anything. The reason that 8.1 is interpreted so broadly, and we believe written so broadly, is because nothing is imposed. It is a matter of consensus and agreement. It's a little bit ironic that this Court comes now to the Commission with an issue of whether certain penalties are too high under the
too
agreed
low.
or
Too
too
low.
low.
I
under
think the problem is not whether the penalty is too high, because if a judge agrees to a greater penalty, that's not a problem. The problem is if the penalty is too low. In other words, from a public trust and confidence point of view, from a whole variety of points of view, if, for example, a judge persuades the Commission, for whatever reason, to accept an informal adjustment, which is too low.
Yes.
The Commission's response is the only thing the Supreme Judicial Court can do in that instance is to start a whole new proceeding, and I'm not sure that if the act was the same in which the judge had been engaged, that there's anything to suggest in the statute that the Supreme Judicial Court can only start its own investigation all over again.
Well, Your Honor, under the Constitution, this Court can always investigate and impose
Of course, yes, but we have a statute which was agreed, which was drafted in consultation with this Court, recognizing that ultimately one could do that, but that there was a mechanism that could resolve a lot of these things informally without having to make recommendations to the Court over and over again.
Well, let me assure this Court that when your inquiries came in, the Commission, and I was present for much of it myself, spent hours attempting to determine whether there is any realistic mechanism by which a suggestion could be made of guidelines for what type of sanction is so low or so high that it should come to this Court, what type of conduct is so trivial or so egregious that it should come to this Court. And at the end of the day, after hours and hours of trying to deal with that issue, the conclusion that was reached is this: you cannot draw reasonably bright lines, either with regard to sanctions
I
or...
think-
But can't
I
we
think
do
the
that from
problem
the,
is-
can't we do that from the statute? Because if you're imposing, if the commission is imposing a condition on the conduct, for instance, what Justice Graney was suggesting, don't go to barrooms, don't go to racetracks, whatever it is, be at your desk be on the bench from 9 to 4, those are conditions. And the things that are not included are the list of items in 4: removal, retirement, discipline, public or private reprimand, imposition of limitations on the performance of judicial duties. So limiting judicial duties. You can sit here, you can't sit there, you can't sit on criminal cases. It seems that it's very clear the legislature has done the work, and all we have to do is you don't have to sit and think about what you can or can't do. The legislature has done it for you.
I disagree with you respectfully, Your Honor, and I believe the Commission does as well. If you look at the subset under 4, a number of those are actually, the subsections under 4, a number of those are actually subsections that also appear under either 1 or 3.
Correct, because they haven't been agreed to. But,
Yeah.
but the problem is, again, I keep coming back to this, there are things under 4 that are quite specific. For example, imposition of a fine.
Yes.
Imposition of a fine.
You can't do that.
And it seems to me, other than the most incredibly broad reading of imposing conditions on the judge's conduct, I don't see how imposition of a fine comes there. I don't see how a public reprimand comes there. What's the judge's conduct? What's the condition on his conduct when it's the commission that is issuing the public reprimand? You can do a private reprimand under 8.3, but it looks to me like only this court can approve a public reprimand.
Well, first of all, may I point out that I believe B and D under 4 are subsets under 1 and arguably 3, which are done by agreement and not by going to this court. So respectfully, I think it is a strange reading to think that you can look at what's listed under 4 and assume that
For
that
eight-
is
you're talking about
precluded under
8.4?
1 or 3.
Yeah, 8.4. I don't think it's a strange reading. It may be impossible to sort of define every single case. You know, these things are decided case-by-case basis, but there may be a mechanism to filter it out. I'm just thinking out loud. Perhaps if there's doubt on whether you could do a certain thing, it could be brought to a single justice to say, yes, you can, or no, you can't. If the single justice says you can, that's the end of that, because it's a voluntary agreement. Nobody's going to appeal to the full bench. If the single justice says you can't, then it seems to me you either go back and do it and run the risk that we would intervene, or you send it over here under 8.4 as a recommendation.
Your Honor,
But I see 8.4 as setting fairly clear limits on what the commission can do and can't do.
if I may respectfully respond to the first part of that statement first,
Yeah.
Your Honor, how does one build the mechanism that you're suggesting into Section 8.1 without defeating what we are told was part of the purpose of the judges' conference in proposing the amendment, namely that they did desire confidentiality with regard to this court? They already had confidentiality with regard to the public for an informal resolution. They did not have it for the court. The informal resolution was kept forever private from the public, but was submitted to under seal and approved.
You
But
get
that
the judge to
included-
waive
but that included-
confidentiality at that point.
No.
And that included even little things. It seems to me what the division that's been made here, and it's a sensible one, that if in the commission's judgment, and we do trust the statute trusts the commission with this, we trust the commission with this, if the nature of the misconduct is at a level or a type that can be dealt with by, admonitions, private reprimands, professional counseling, that sort of stuff, that we don't need to know about it, and the judge can keep that confidential. But that if the level of the misconduct or the nature of the misconduct is of a type where what you would recommend, what the commission would recommend, involves such things as fines and suspensions and being permanently precluded from hearing all criminal cases, if it's that serious a type of misconduct, it would seem that the legislature did want that sort of stuff not to remain confidential, but to come to this court to sort out the higher or lower.
Your Honor, respectfully, you left out the fourth category under 1, which is persuading a judge to retire. That's not something that's done for minimal misconduct.
Oh,
That's
correct.
done for serious misconduct. Hence,
Correct.
there
But
is
since
not
that's the
fair.
that's the ultimate sanction, it's true. If a judge is willing to go
No,
with the
Ms.
ultimate
Lukey, I have-
sanction, there's
but
no
I-
way we would do something more.
But I also have a different, I think the legislature could well have had in mind a different concern, which is, if the Supreme Judicial Court has general superintendency, correct, once a judge is off the bench, our superintendency ends. In other words, that judge can no more do damage to the public. That judge can no more do damage to the public. The judge is off the bench. A judge can, in fact, one could almost say that that particular provision is superfluous in the sense that a judge faced with anything can always voluntarily retire.
But, Your Honor, you're suggesting a dividing line that's based on the sanction, and Justice Saussman
No,
was
I'm
suggesting a dividing line that was based on the seriousness of the conduct.
No, I'm suggesting a dividing line where the seriousness of the conduct is such of a continuing sitting judge in the performance of judicial duties, including things like fines and so on and so forth.
Well, perhaps maybe I need to understand better what the Court's concerns are here. There is no more serious penalty than to leave the bench forever, be it by retirement or
But it's
otherwise.
not necessarily a penalty in this sense. A judge, for example, may choose not to have an entire record become public. It's a penalty only in the sense that a judge faced with conduct that might become public might say, I choose not, I simply want to retire. I want to retire. And I think a legislature could say there's absolutely no reason why, if that's what a judge wants to do, the commission is empowered to resolve whatever the complaints were on that basis. It's not looking at the severity of the sanction as much as it is of what it is that the commission is saying with regard to the judge.
But if this, let us assume for the moment, if I may, hypothetically, that this Court thought that whatever it knew of the conduct, and it may know very little since it hasn't been involved in the investigation, suddenly they are informed that a judge who was perceived by this Court as being highly regarded and a very capable judge was, as part of a voluntary resolution and agreed disposition with the commission, retiring. Would that be a matter of concern for this
No,
Court?
we
because
don't need
judges
that, 'cause
retire all the time.
And that's clearly allowed
42
under
years old?
8.1d. That's clearly allowed under 8.1d. So there's no problem with that. There's no problem with that. But take something that's more obvious, like imposition of a fine. The resolution that the commission reaches with the judge is simply the imposition of a fine. Suppose this Court thinks, no, a fine isn't enough. There should be a public reprimand. There should be a 6-month suspension on top of the fine. What do we do? You say we start all over from scratch.
Respectfully, unless you're going to write into this statute, into Section 1, the amendment, the only change of which was that agreed dispositions did not come before this Court.
Agreed dispositions as specified in the statute. Nobody disagrees. I mean, Ms. Lukey, we're going around and around.
Yeah, we're going around in circles
Because
here.
it's agreed dispositions as specified in the statute, and you say the way I interpret the specification is it can be anything. And this Court is saying that's not our interpretation of that.
Yeah.
By agreement, for the last 18 years, the Commission has consistently entered into agreed dispositions which had a variety of aspects that are not listed,
Yeah.
as the
Well,
Court has been
but
pointing
that's
out, fines,
That's why
periods
we're
off the
here
bench.
today, to decide whether it should be, that practice should continue.
Well,
And
we
I
understand
suggest
that-
the word conduct cannot be read to involve anything involving the imposition of limitations or conditions on judicial duties. And judicial duties means where you sit, what kinds of cases you hear, whether you sit actively on the bench or be suspended from sitting, anything of that sort is simply not within that word conduct, in
Well,
my
there-
opinion.
There, we obviously have a disagreement between the commission
There's the
and
disagreement
board.
we've been talking about for 50 minutes.
And the bottom line being that if it is a situation where the judge is in agreement with the commission, respectfully, if it is a matter of the penalty being too high, I gather this court is saying that is not the matter of concern. You are concerned where a penalty might be
Yeah,
too low.
I think the answer to that is the judge can agree to it, but it's an impermissible agreement.
Let me say this about the penalty being too high. I don't want to suggest that in the overall system, the idea that a penalty too high is not of concern to this court in this respect. If the commission insists with a judge that the penalty is a high one, and let me just take, for example, that it's a 6-month suspension and a monetary fine. And if the judge faces the alternative of either agreeing to that, which the judge feels is excessively high, the judge may know of other cases because they were reported, may think it's profoundly unfair, and the alternative is to go through formal, public, and very expensive proceedings, the judge might well feel that he or she has no alternative but to accept that. It seems to me a system, those are very severe sanctions. It strikes me that they are not of the same nature as described by the Commission itself that go to things such as counseling and so on. They're very severe. If there was a system which, as you can gather, several of us think is the case, that with respect to those kinds of sanctions, there has to be a recommendation to the court. If the Commission and the judge agreed, subject to the confidentiality, that would be an agreed-upon disposition without formal charges, recommended to the court might well say, no, we think this is too high. We think it is too high. In that case, it acts as a protection to the judge. If it is too low, and the court says it's too low, that acts as a protection for the public. In other words, it's not simply a question of too high or too low. It is a question as to whether or not involved with the entire superintendents, other than things that have to do with counseling, related kinds of things, it's inappropriate or appropriate under the statute to have no involvement of this court.
Your Honor, the judge always has the right to waive confidentiality in the course of the proceedings for the purpose of coming to this court only. That is always available to the judge.
Correct,
As a result
but if the
of
Commission
that,
takes a position, you either agree with me or you go to formal charges, Judge, which is the position that the Commission has taken before this court. That does not give the judge the opportunity to say to the court, this is what the Commission wants me to agree to. If you agree, Supreme Judicial Court, that this is inappropriate, then I will accept it.
Your Honor, we really do have a disconnect on this one. The judge may do exactly what you are suggesting. At any time, the judge may choose to go to the Supreme Judicial Court, in essence, to discuss the nature of the sanction proposed, although in doing so, she or he is going to open wide open all of the material relating to the underlying complaint. And that can happen before
Not
formal
open wide open, open to the court.
to the court, but everything about the complaint would
Well,
then
then I
be
misunderstood.
open to the court.
Then I misunderstood the Commission's, because as I understood the Commission saying, we reach agreement with the judge, and maybe I misunderstood both of your very helpful filings. Either we disagree with the judge, we reach agreement with the judge, in which case there's no involvement of the Supreme Judicial Court. There is involvement of the Chief Justice for Administration and Management or the Chief Justice of the Trial Court Department, but not of the Supreme Judicial Court. Or we don't reach agreement, in which case it's formal charges and public.
That, as I understand the situation, your understanding is not correct. It is my understanding, which I hope I am stating correctly for the Commission, that any judge may elect to waive confidentiality with regard to the proceedings to go to this court on motion for guidance.
Meaning open it to the public?
Well, unfortunately, there is no current mechanism. There was a mechanism before for it to come under seal. At the moment, as the statute is now amended, there is no such mechanism other than to file a motion under seal.
If it were a recommendation, if it's not a formal charge, if it is for the judge to say that the Commission has recommended this level of sanction, and I am prepared to accept that level of sanction, in other words, I am accepting that I have violated the code of judicial conduct in some respect, but I disagree with the level of sanction. Under what provision is the judge proceeding at that point?
If that is the issue of the sanction, then there must be an agreed statement of stipulation of facts to go before the court. You know, that must go completely before the court if there is to be a review of sanctions, and there must be a waiver of confidentiality.
Which provision of the code are you proceeding under at that point?
Well, I'm afraid I'm going to have to look for it for you. We do describe this process in the written materials.
No, I understand that, but
and it's going to take me a minute to find it.
Okay. And, I mean, I'm perfectly happy for you to consult with your excellent client.
You can send it in later if you want.
You can send it in
later.
You can
send a letter in.
Whichever you prefer, I can actually...
Put it this way, Ms. Lukey. I think this Court and the Commission share common goals, which is to make sure that from the judge's point of view, the public's point of view, the superintendency of the court's point of view, there is a fair, administration of both prevention and discipline of judges. And the Commission takes a very strong point, you mentioned it in your last thing, that the goal is primarily prevention, not discipline. And that, it seemed to me, raised a very interesting flag for me, which is if a judge should be disciplined, the Commission is saying, well, actually, what we're really going to do is preventive work here, not discipline work. Correct?
Well, I don't think that's a correct statement of what the Commission, in fact, does. I'm looking at page 7 of our second report, which is in response to your question number 2. It does not cite to the section of the code, of the statute, which I will have to get to you, but it says, it's a view of the Commission that it may not make a recommendation to the court regarding the sanctions under 8.4, absent the filing of formal charges and a public hearing, unless there is a full stipulation of facts and the judge waives the right to a hearing. So the Commission takes the position that if there is a full stipulation of facts agreed to by the judge and the Commission, that may then go to you, but very much as is the case in many administrative proceedings, if that is the election, then the sanctions stage of the proceeding is turned over to this court. And that is always open to the...
And I take it that you were saying that if the judge does that, it cannot come, as it were, in a non-public form, whether it's under seal or whatever else one wants to call it, correct?
I believe he can. I think any proceeding by statute can be under seal in a closed courtroom if the statutory requirements are met. There is no longer an automatic under seal process because that was eliminated with the amendment.
Attorney Lukey, I want to ask you something that in reference to something you said earlier. When the Commission and the judge enter into an agreement involving imposition of conditions on judicial conduct, how is the judge's departmental chief brought into this? Is it as a courtesy, or as seeking that Chief Justice's consent and approval?
It is not just as a courtesy. There will be no agreement. It's one step earlier that the chief of the relevant department is consulted. So if the judge and the Commission are discussing an arrangement that would involve, let's just say, for example, not sitting on any criminal cases for 1 year, the Commission, before they enter into an agreement, goes to either the CJAM or the Superior Court Chief Justice as appropriate, and says this is proposed. And they can only do that, by the way, with the agreement of the judge. So the judge says, go ahead. The commission goes to the chief of that particular court and says, is this acceptable? If the chief says yes, then the agreement is entered into.
But if the Chief Justice says no,
Then there's no agreement.
why wouldn't under your view, why wouldn't the commission and the judge have the authority to enter into that kind of a contract, that kind of an agreement?
Because it obviously wouldn't work. It would disrupt the work of the judiciary in the Commonwealth. And whether that doesn't have to be written into the statute, that's a matter of common sense. For example, I mean, to take it to the extreme example, if the commission suddenly had 50% of all Superior Court judges under complaints with investigations going on, and the commission unilaterally said, fine, everybody's not going to sit for 6 months, that would obviously disrupt the entire judicial process. You don't have to put right in the statute that one must be mindful that the judiciary is here to serve a purpose for the public. The commission is well aware of the obligation of ensuring that its actions don't disrupt the public. And that's the reason that before it enters into an agreement with the judge that would include an imposition of a condition on his conduct, and again, the commission does believe that conduct includes sitting in civil cases versus criminal cases, that it must consult with the appropriate chief. Generally, it would be with the CJM.
So what you're saying is a matter of practice, you consult, and if the appropriate chief says no, you won't do it.
That's correct.
I
Okay.
take it, however, that the appropriate chief may say, I think the sanction is not sufficiently severe, and the commission feels
Thinks it.
is not sufficiently severe, and the commission may say, well, I'm interested in your point of view, but we don't feel bound to be guided by that, correct?
They would not be bound to be guided by it, Your Honor, because they have facts that the chief presumably does not have. The chief, except in the rare instance where perhaps the chief is the complainant, which does happen from time to time, except in that instance, the chief doesn't know what has come up in the investigation, what the mitigating factors are, or what the details are. So, of course, the commission gives substantial deference to the chief of the relevant department, but it can't be bound by the chief's view because he or she is without the guidance of the full record.
Could I ask you one other question? Under Section 8(3), the commission may issue a private reprimand with the consent of the judge.
Yes.
I take it that that has been interpreted, and again, it's a factual question, by the commission to mean it can be a private reprimand that is made public.
If the judge agrees that part of the press release is that the fact of the private reprimand is to be made public, in essence, the private reprimand becomes public by virtue of the press release. As indicated in the papers, while there are often press releases, the press releases do not cover all aspects of the agreement. It's only that which is negotiated with the judge.
Ms. Lukey, let me just say this. The Court certainly appreciates the Commission's response to its inquiries. As you know, the Court has from time to time met with the Commission to discuss a variety of matters. We often don't do it in a public setting, but we thought that this was sufficiently important because it touches all of the judges in this Commonwealth as well as the public. And so I particularly appreciate that. I appreciate the fact that the chairman, who is not well, but I heard from him yesterday that he is in fact recovering well, understood that it would be appropriate for these proceedings to go forward. And I want to thank you and all of the council in this Commonwealth who provide such excellent pro bono assistance to the Commission and to others for undertaking this. You probably wish that you didn't have to do it again and again and again, but it's a tribute to you and other lawyers that you do it so willingly, and we greatly appreciate it.
Thank you.
Is there anything else that you would like to ask the Court?
No, Your Honor. Thank you
And
very
you
much.
might want to turn around and see whether any of your clients want to ask the Court anything.
You could be here a long time if we get started, Your Honor.
Thank you.
Well, thank you very much indeed.
All right.